to run enhanced background checks on young people under 21 trying to buy a firearm.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
I'm just inspired by the next generation. I think it's a time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries.
Selling more guns in the last 3 weeks than we did in the last 8 months.
Shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
The Fifth Circuit Court of Appeals of the Fifth Circuit recently affirmed the nationwide block on the ATS regulation on frames and receivers. However, the ATF is likely going to appeal this to the Supreme Court, and then we are likely going to obtain the Supreme Court's input, so let's talk about this. Federal firearms laws. Federal, state, and municipal governments all share power over the regulation of firearms. Individual states have passed a wide variety of regulations governing, among other things, the ownership, registration, and carrying of firearms. U.S. law creates a national legal framework for the lawful manufacturing, sale, and possession of weapons. As long as they do not clash with federal law, states are permitted to augment the federal framework with additional regulations that serve as a baseline for acceptable firearm use and transactions. Since there have been federal rules governing firearms for about a century, Congress has increased the criteria for the sale, possession, and transportation of firearms. The National Weapons Act of 1934 and the Gun Control Act of 1968, as amended, are the two main federal weapons laws that are currently in effect.
Blatantly denying the power grab being carried out by the executive branch yet again.
The uptick in violence has just been astronomical. The gun violence.
As a kid, I came out of a different movement, the civil rights movement.
Who showed up here said one thing that felt good about doing this kind of event was that they felt empowered.
Pretty clear about the extent to which this is an abuse of the Administrative Procedures Act.
Is it a difficult question to understand?
I'm sure it's enormously high.
It's 36 per 100,000 people.
I just felt that I needed to be able to protect myself.
The NFA was the primary federal law governing the purchase and possession of weapons. The law targeted the types of weapons that, at the time of passing, were frequently used by gang members in an effort to reduce the surge in violence associated with organized crime. Following the murders of Senator Robert Kennedy and Dr. Martin Luther King Jr., Congress passed the Gun Control Act to ban the possession of firearms by prohibited individuals and to aid law enforcement in reducing crime. Since its creation, the GCA has undergone numerous additions to its complicated statutory framework. The GCA, as amended, broadly governs the production, sale, and possession of firearms, including those types of weapons that are not covered by the NFA. In general, the GCA outlines who is permitted to sell, buy, and possess firearms, how such sales and purchases may be lawfully conducted, which firearms may be lawfully held, and the locations in which such possession may be prohibited. With the exception of some transfers of firearms, the Brady Handgun Violence Prevention Act changed the GCA to mandate background checks. Legislative initiatives to alter the current system for restricting the sale and possession of weapons may take a number of constitutional factors into account. Although the Constitution gives Congress broad ability to control firearms, every such measure must be based on one of those powers. Congress has generally used its tax, trade, and spending powers to create legislation governing weapons. For instance, the NFA uses the taxing authority of Congress, while several GCA provisions use the commerce authority of Congress. Additionally, through providing grant money, Congress has utilized its spending authority to encourage states to give thorough records to the FBI's National Instant Background Check System.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
Real background checks could stop a lot of illegal guns going in different places in the country.
Shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
Affect us here, and it was such a breath of fresh air for the Second Amendment people.
It takes extraordinary courage for them to stand up here and retell the story.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
However, Congress must be aware of other constitutional limitations when using its listed powers. When enacting any weapon restrictions, Congress may want to refer to the Supreme Court's Second Amendment case law, particularly District of Columbia versus Heller. The Second Amendment guarantees a person's right to keep and carry guns for legal purposes, the Supreme Court ruled in Heller. Additionally, the Fifth Amendment's Due Process Clause restricts Congress's ability to strip a person of any constitutionally protected interest, such as Second Amendment gun rights or property rights to firearms and related accessories. Additionally, Congress may want to take into account the federalism restrictions built into the Constitution's dual sovereignty system when passing legislation to restrict state gun laws, such as the anti-commandeering concept. The extent of the measures that the 115th and 116th Congresses explored to change the current federal statutory framework of weapons regulation is pertinent to these constitutional considerations. Such legislation has focused on a number of issues, including the proliferation of 3D printed and untraceable firearms, holes in the data collection for background checks of potential gun buyers, limitations on particular types of firearms and accessories, gun ownership by people with mental illnesses, interstate reciprocity for lawful concealed carry of firearms, and laws allowing courts to order the temporary removal of firearms from a person. National Firearms Act levied taxes on the production and transfer of firearms covered by the Act, as well as specific occupational tax on individuals and organizations engaged in the importation, manufacturing, and sale of NFA firearms. All NFA firearms have to be registered with the Secretary of the Treasury as well, according to the statute. Shotguns and rifles with barrels shorter than 18 inches, as well as several firearms classified as any other weapons, mash guns, and firearm mufflers and silencers, were among the firearms included by the 1934 Act. While Congress used its power to pass the NFA actually served a function unconnected to bringing in money. According to the legislative history of the law, its fundamental goal was to restrict, if not outright forbid, the sale of NFA firearms. Because of their widespread usage in crimes, notably the gangland crimes of the time like the St. Valentine's Day Massacre, Congress determined that these firearms posed a serious criminal problem.
Today, we say more than enough. We say more than enough.
No Democrat has ever tried to get anybody's guns. I mean, that's just a lie that they tell, and y'all ought to stop perpetuating the lie.
We can reach compromise on guns. We ought to be able to reach compromise on other critical issues, from veterans' health care.
To have their firearms, which are being held by the government, transferred to a third party for the third party to sell.
Atlanta, Buffalo, Uvalde. And for the shootings that happen every day in the street that are mass shootings we don't even hear about.
The $200 manufacture and transfer taxes on the majority of NFA weapons were thought to be sufficiently harsh and severe to achieve the congressional goal of discouraging or preventing transactions in these firearms. Since 1934, the $200 tax has not changed. As originally written in 1934, the NFA required both those who simply owned unregistered guns and those who transferred NFA firearms to register them with the Secretary of the Treasury. The Treasury Department might tell the state authorities of the registrant's possession of the firearm if the owner of an unregistered firearm applied to register it as required by the NFA. The information might then be used by state authorities to bring charges against the owner of the illegal items. The registration requirement imposed on the owner of an unregistered firearm violated the owner's Fifth Amendment right against self-incrimination. The Supreme Court ruled in the Haynes case in 1968, and the person prosecuted for having an unregistered NFA firearm had a valid defense to the prosecution. The 1934 Act is essentially unenforceable as a result of the Haynes ruling. Title II of the Gun Control Act of 1968. In order to address the constitutional issue raised in Haynes, Title II revised the NFA. The first change was the removal of the registration requirement for owners of unregistered guns. In fact, an owner of an unregistered NFA firearm who already has one does not have a way to register the firearm under the new law. Second, a clause banning the use of any information from an NFA application or registration as evidence against a person in a criminal case involving a law violation that happened before or at the same time as the filing of the application or registration was added to the statute. The Supreme Court re-examined the NFA in the Freed case in 1971 and discovered that the 1968 modifications fixed the original NFA's constitutional flaw. The NFA definitions of firearm were also changed by Title II, which added destructive devices and broadened the meaning of mash gun.
We are not finished. We are not finished. We are not finished.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
Not one more! Not one more! Not one more!
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
Firearm Owners Protection Act. This act included combinations of parts for silencers and any part intended for use in the assembly or manufacture of a silencer to the NFA definition of silencer in 1986. The GCA was altered by the act to make it illegal to possess or transfer machine weapons. Mash gun transfers to or possession by government entities, as well as those that were lawfully in possession before the prohibition's effective date of May 19, 1986, all qualified for exceptions. ATF Final Stabilizing Brace Rule. On January 31, 2023, the Bureau of Alcohol, Tobacco, Weapons, and Explosives published a final regulation redesignating some brace-equipped weapons as short-barreled rifles. These weapons were formerly categorized as pistols and were only subject to GCA regulation. These weapons are now covered by the more stringent 1934 NFA, having been reclassified as SBRs. Nearly all rifled bore weapons with fewer than 16-inch barrels that are braced or equipped with similar devices appear to be prohibited from being transferred under the rule until they are registered with the Attorney General under the NFA. Private owners of these firearms, as well as FFLs, have a number of choices for adhering to the regulation. By May 31, 2023, they can submit an NFA tax registration form to the ATF without paying any taxes. Alternately, owners can modify the weapons by permanently removing the brace or swapping out the 16-inch barrel for one that is longer. They could potentially dispose of the weapons or give them to law enforcement as illegal contraband. Legislation to invalidate the ATF regulation and exempt all short-barreled weapons and comparable weapons from the NFA's regulations has been proposed by some members of Congress.
I don't really see the purpose of letting other people that don't really know what harm they can do.
You specifically said that.
But I said...
What does mandatory mean?
I'm trying to say that...
Does it mean that prosecutors get a choice?
I would expect to see in the coming months and years is a lot of focus on whether or not enough places are deemed sensitive right now.
The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal."
To help FFLs and other parties fulfill their legal obligations, the ATF assigns firearm categories via letter rulings, open letters, and other written private findings. By using these guidance documents, which are governed by the Administrative Procedure Act, ATF is able to respond to new events more swiftly and effectively than it could by issuing a rule under the APA. The primary government agency tasked for classifying firearms and ammunition in accordance with federal law is the ATF's Firearms and Ammunition Technology Division. The FATD is in charge of handling requests for domestic manufacture and importation evaluations, as well as marking deviations. Classification letters are not made public, but under the Freedom of Information Act and Privacy Act of 1974, interested parties outside the government may access them. ATF has collated laws and rules pertaining to firearms in a Federal Firearms Regulations Reference Guide 2014, which covers some decisions but not all. On the ATF website, more current decisions are periodically posted. There isn't a centralized index of ATF letter decisions, findings, or open letters, albeit they may be redacted. Therefore, experts advise that it is not guaranteed that anyone who submits an FOIA request for previously issued classification letters would obtain all pertinent letters sent by the ATF. Additionally, some observers claim that some ATF decisions have been incompatible with earlier decisions. However, any potential contradictions could be the result of revised legal analysis by DOJ or ATF lawyers.
So the third party can either keep them in trust or sell them and give the money to Mr. Henderson.
James commented on the decision, saying she's pleased. Remember, the law as it stands strengthens requirements.
And in many cases, the value of the firearms can be quite high.
Today, for the most significant law to be passed since then, since the last 30 years.
and prohibits guns in sensitive places and requires background checks on all ammunition purchases.
Statute means what it says. It says that a convicted felon cannot possess a firearm.
I'd like to thank the leaders and members of the House and Senate for working together to get this done. I especially want to thank the families.
It doesn't say he can't sell a firearm that the government is possessing on his behalf.
GCA NFA firearm and shoulder stock. According to the GCA NFA structure, the General Arms Act governs firearms that are subject to NFA regulation first. Shotguns, rifles, and pistols are the three primary categories of firearms included in the GCA. The GCA and NFA both contain identical statutory definitions of the terms shotgun and rifle from Congress. A long gun, shotgun, or rifle is a weapon made or recreated, intended to be fired from the shoulder, and made or recreated to use the energy of an explosive to fire one or more ball shots or a single projectile through a smooth bore with each pull of the trigger. The GCA regulates pistols with rifled barrels. The phrase handgun refers to a firearm with a short stock that is made to be gripped and discharged with just one hand. With the exception of their design, the GCA imposes no limitations on the length of the barrel or overall length of such handguns. Mash guns, silencers, sawed-off shotguns, and other weapons deemed to be more hazardous and exotic than the conventional firearms owned by people in the 1930s are also governed by the NFA. Interstate bank robbers, bootlegger gangsters, and other criminals occasionally employ these guns to outgun federal officers and law enforcement. Short-barreled guns and short-barreled rifles are governed by the ATF final rule, including shotguns with barrels shorter than 18 inches, and rifles with barrels shorter than 16 inches, as well as any existing shotgun or rifle that has been altered to have an overall length of less than 26 inches by shortening its stock and/or barrels. Additionally, it controls destructive devices and any other weapons. A fourth type of firearm, which is undefined by statute or regulation, is the only one subject to GCA control. Since at least 1976, the ATF has used an overall length cutoff of 26 inches to distinguish between short-stocked, smooth-bore firearms that are primarily GCA regulated and concealable smooth-bore pistols that are subject to NFA regulation. However, if a shoulder stock is never attached to the frame or receiver of a handgun of comparable size, neither the NFA standards nor restrictions apply. The ATF had long held that adding a shoulder stock to a handgun or pistol grip weapon changed it from a GCA-only regulated weapon to a short-barreled rifle or shotgun governed by the NFA. However, the ATF decided in November 2012 that adding a stabilizing brace to an Armalite-type pistol would not change the categorization of that weapon from a handgun that is only subject to GCA regulation to an SBR that is subject to NFA regulation. With the rise in popularity of weapons with stabilizing braces, it became obvious that many users plan to use the braces as sort of shoulder stocks rather than attaching them to their forearms. In accordance with the final 2023 rule, the ATF changed the definition of rifle to include rifled bore weapons that are fitted with a stabilizing brace or other similar device that offers enough surface area for shoulder firing. Millions of people who have purchased or manufactured brace-equipped weapons will be impacted by this regulation. Critics claim that the ATF has overstepped its bounds, putting lawful gun owners in danger of prosecution while failing to address the underlying causes of gun violence. Supporters of the rule cite 4 large-scale public slayings in which the attackers employed braced weapons and argue that the measure is both within the scope of ATF's authorized power and beneficial to public safety. ATF Worksheet 4999. The Attorney General is responsible for enforcing the GCA and the NFA.
Because he doesn't care about separation of powers either.
The Texas House of Representatives just voted to impeach Texas Attorney General Ken Paxton.
How many guns has the ATF lost? I'm not sure I understand the question.
But what is also true is that it is incumbent upon the United States Congress, the House of Representatives in particular.
Weim says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
The extent to which this is an unconstitutional violation of our Second Amendment rights.
Subject to the direction of the Attorney General and the Deputy Attorney General. The ATF Director delegates the authority to classify firearms pursuant to the GCA and NFA to ATF's Firearms Technology Criminal Branch. and the Firearms Technology Industry Services branch within the Firearms and Ammunition Technology Division. The statutory definitions of firearm under the GCA and NFA differ. In 1934, Congress passed the NFA to regulate certain gangster-type weapons, which were viewed as especially dangerous and unusual, and as a result are subject to taxes and are required to be registered with ATF. The Supreme Court recognized these additional constraints as consistent with the Second Amendment. Classification of a weapon as a firearm under the GCA or the NFA affects how it is regulated under federal law. For instance, a weapon classified as a firearm under only the GCA is subject to interstate controls, but is not subject to making or transfer taxes and need not be registered in the National Firearms Registration and Transfer Record as required by the NFA. In contrast, weapons classified as NFA firearms are generally regulated under both statutes. The numerous configurations, materials, and designs of modern firearms require thorough examination and consideration to ensure proper classification. In recent years, some manufacturers have produced and sold devices called stabilizing braces, designed to be attached to large or heavy pistols to help a shooter stabilize their arm to support single-handed firing. The addition of an accessory marketed as a stabilizing brace does not guarantee that the resulting firearm will still be classified as a pistol. Classifying a firearm based on a limited or singular characteristic, such as the marketing label of the manufacturer, has the potential to be significantly over-inclusive or under-inclusive. Short-barreled rifles are among the firearms considered unusual and dangerous, subjecting them to regulation under the NFA. ATF does not classify unregulated components or accessories alone under the GCA and NFA. When a purported stabilizing brace and an attached weapon's objective design features indicate that the firearm is actually designed and intended to be fired from the shoulder, such weapon may fall within the scope of the NFA, requiring registration and payment of tax. The proposed ATF Worksheet 4999 aims to ensure legal compliance with the GCA and NFA by defining the term rifle and determining if a firearm is designed and intended to be fired from the shoulder. The new rule will apply the objective design features and characteristics of a stabilizing brace to firearms with a rifled barrel and attached stabilizing brace that have objective design features and characteristics that indicate that the firearm is designed to be fired from the shoulder.
Conventional wisdom was we would never get any Republicans to support gun legislation, period.
Are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimum.
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
Are demonstrating that blind loyalty to Speaker Dade Phelan is more important than upholding their oath of office.
Might end up being a message amendment because the President of the United States will almost assuredly veto it.
The ATF Worksheet 4999 aims to ensure uniform consideration and application of these criteria when evaluating firearm samples with attached stabilizing braces. This new rule will help industry members plan and develop products that comply with the law and reduce the risk of criminal or civil penalties or the need for corrective actions, including recalls by the manufacturer. The overall length of a weapon is crucial in classifying it as a rifle or a pistol because it becomes increasingly difficult to fire with one hand. Firearms possessing an overall length between 12 and 26 inches may be considered pistols for which a stabilizing brace could reasonably be attached to support one-handed fire. Firearms with an overall length of less than 12 inches are considered too short to indicate any need for a stabilizing brace. Conversely, firearms exceeding 26 inches in overall length are impractical and inaccurate to fire one-handed, even with a stabilizing brace, due to imbalance of the weapon. For FATD to determine that a weapon with an attached stabilizing brace is not designed and intended to be fired from the shoulder, the accessory must not have the characteristics of a shoulder stock. These characteristics are as follows. Accessory design. The design of the accessory when attached is a factor in determining whether the item is actually a stabilizing brace or is intended to be utilized as a stock, making the firearm designed to be fired from the shoulder. The more features a purported stabilizing brace has in common with known shoulder stock designs, the more points it will accumulate. Stabilizing support is a vital characteristic because it provides evidence to evaluate the purported purpose of the attached device, which is to provide shooters with forearm support for firing large, heavy handguns. The ATF has categorized these different stabilizing brace designs into 3 broad categories: counterbalance, fin type, and cuff type. Counterbalance design utilizes the weight of the weapon as a lever to push the stabilizing brace into the forearm and provide stability for firing. Fin type and cuff type designs are 2 types of firearms that have evolved over the past decade. Fin type accessories that do not incorporate an arm strap of suitable length or functionality will accrue 2 points, while those that incorporate an arm strap long enough to secure a person's forearm, consistent with the purported intent, will not accrue any points. In conclusion, the configuration of a firearm, including the stabilizing brace, is crucial for its effectiveness in single-handed firing and shoulder stock use. A firearm's length of pull is a measurement used to fit a firearm to a specific shooter, and adjustments to shoulder stocks or attachment methods that result in an unusable aim point are also strong indicators of the weapon's intended use. Repeal the NFA Act. The statute is nearly 89 years old, making it younger than current Senators Chuck Grassley and Dianne Feinstein. Freshman Representative Eric Burleson is making an impact after only 1 month in the new Congress. His congressional campaign website for 2022 featured a picture of him holding a firearm and referred to him as a Second Amendment champion. He has only increased his stance on the subject in Congress. Abolish the ATF Act, a groundbreaking Republican House plan to abolish the Bureau of Alcohol, Tobacco, Firearms, and Explosives, was recently covered by GovTrack Insider. The majority of Republicans prefer to curtail the Bureau's power or reduce its budget rather than abolish it outright. Only 3 Republicans have signed on as co-sponsors for the bill, but one of them is Rep. Burleson. He is currently moving forward with a bill that is comparable to mine. The National Firearms Act of 1934 was the first piece of legislation passed by Congress with the intention of reducing the use and ownership of automatic weapons and mash guns through a combination of fees, registration requirements, and application procedures. It was approved by voice vote in both the House and Senate, which is typically done for less contentious pieces of legislation. Although it wasn't particularly controversial at the time, the Republican Party has recently shifted to the right on the subject. GovTrack Insider has therefore covered recent Republican bills to change or eliminate particular NFA sections. They include the Home Defense and Competitive Shooting Act, which would exclude short-barreled rifles from the NFA's requirements, and the Hearing Protection Act, which would declassify silencers so they are no longer regarded as firearms under the NFA. Rep. Burleson has since proposed the repeal the NFA Act, which would completely repeal the National Firearms Act of 1934. It is the freshman congressman's first measure ever to be introduced. H.R. 450 was used to introduce it to the House on January 24. The National Firearms Act, according to supporters, has long been unconstitutional and has been used as a tool to unfairly limit people's freedoms. The federal government has used the NFA for almost a century to violate law-abiding citizens' Second Amendment rights, Rep. Burleson stated in a press statement. These blatant attacks on the constitutional rights of Americans are best exemplified by the latest ATF pistol brace rule. The rule, which was published in January, mandates that owners of stabilizing pistol braces register the device within 120 days to avoid potential felony charges. The ATF NFA hoax must be exposed. Rep. Burleson stated, the bill will reverse nearly 90 years of attack on fundamental freedoms by stripping the ATF of its power to prosecute lawful gun owners. I'm proud to stand with and support Americans across the country as we confront this issue, you might say. The argument put up by opponents is that the epidemic of gun violence is a problem that is unique to American public safety, and that the best solution is more effective government action, not less. Repealing the NFA Act, according to fellow Missouri Representative Emanuel Cleaver, is a talking point, but the fact that it has even reached this point of introduction is something of a smack in the face to the thousands of families of recent fatality victims across the nation. The remark, "just got slayed recently," was probably a reference to 2 recent mass slayings that left 11 and 7 victims dead, respectively. According to GovTrack Insider, the most recent attempt to repeal the NFA was a 2022 House bill introduced by Madison Cawthorn, who was a representative at the time. By the time Cawthorn filled the bill, he had already lost the Republican primary for his district, thereby slaying it even among his own party's members. Rep. Lauren Boebert was the only Republican co-sponsor, and the bill was never put to a vote in the House, which was then under Democratic control. The number of Republicans who have co-sponsored the present bill has increased to 9. In the House Ways and Means Committee, a vote is pending. The likelihood of passage in the Democratic-controlled Senate is slim. Invalidated ATS frames and receivers rule. A federal trial court recently declared the ATS rule on frames and receivers to be completely unlawful. The Fifth Circuit has officially issued its opinion, and it denied the ATS's request for a stay. Vadim Garland, the frames and receivers rule, is clearly unconstitutional and goes beyond the ATF's power, according to a recent decision by Judge Reed O'Connor of the Texas Federal District Court. As a result, he granted the plaintiff's request for a summary judgment and overturned the frames and receivers rule internationally in his ruling. Despite the fact that this was unquestionably a big victory, the ATF was not willing to concede. While we awaited the Fifth Circuit's decision on the ATF's appeal, they also asked for a lengthier stay. We just learned that the Fifth Circuit had rejected the ATF's request for a stay and that the ATF's appeal had been rejected. The Fifth Circuit denied the ATS's request for a stay because it determined that Judge Reed O'Connor was correct in invalidating some provisions of the ATS frames and receivers rule, and that it was appropriate for him to do so. This is huge news and a major victory for the pro side. But this order did provide a few modest victories for the ATF.
That requirement for showing a heightened need for self-defense, that was the teeth of these permitting laws.
And within less than 15 minutes, you can walk out the front door here with a rifle or a shotgun.
American citizens in places like New Orleans and Baltimore and St. Louis begin to seek asylum in countries like Honduras and Guatemala.
I don't know if you're referring to any particular incident.
In their first response, the ATS stated that they will most certainly appeal this case to the Supreme Court within the next 10 days in order to obtain emergency relief. Now, according to the Fifth Circuit's order, it's crucial to take into account 4 elements while deciding whether to grant the ATF stay or refuse it when the government requests an emergency stay. These 4 reasons are as follows. 1. Whether or not the government presents a compelling case that has a good chance of winning on the merits. 2. Whether a delay will prevent the government from suffering irreparable harm. 3. Whether a stay would injure other interested parties in a way that was unfixable. 4. Wherein is found in the public interest. Because the ATF has not demonstrated that it would prevail on the merits or that it will sustain irreparable harm in the absence of one, the Fifth Circuit says the government's request to suspend the rule is refused. It is indicated in the vast literature of the 2 contested parts of the rule that vacating it would bring things back to how they were before the rule took effect. While an appeal is pending, this basically maintains the status quo, which persisted for 54 years from 1968 to 2022. Fifth Circuit denies ATF's request. The district court only examined the validity of 2 of the various components of the rule, which contains an express separability clause in which a court declares certain provisions of a rule to be unconstitutional. The agency has demonstrated a strong likelihood of success on its claims that the vigature of the various non-challenged portions of the rule was overbroad, so we stayed the vacator pending appeal as to the non-challenged provisions we sued.
Because they like the outcome of the policy, the banning of a piece of plastic.
Post-Bruin challenges have succeeded in lower courts. The opinions and reasonings therein have been grossly mischaracterized.
Obviously they're gone, but it will be an inspiration for us to do more. I'm not going to sign this bill into law.
Circuit decision in U.S. v. Rahimi is worth highlighting. As others have noted, the panel struck down a federal statute.
Severance is preferred when doing so will not impair the function of the rule as a whole, and there is no indication that the regulation would not have been passed but for its inclusion. Bonte expedited the appeal to the next available oral argument calendar to allow time for additional proceedings as appropriate. This order is administratively stayed for 10 days. So that was the order of the Fifth Circuit, and you may be asking, what does that mean? Well, the Fifth Circuit Court agrees with the lower court judge that he was correct in finding that the ATF expansion of the definition of an unfinished frame receiver as a firearm goes beyond the ATF's statutory authority. Therefore, the Fifth Circuit denied the ATF's request to stay that portion of the decision. Now, where the ATF is getting a slight win out of this order is that the Fifth Circuit did state that in their order they believe that Judge O'Connor was overbought in his decision. Since the ATF rule includes severability language, the Fifth Circuit believes that Judge O'Connor should have simply struck down the challenged portions only, those portions and only those portions of the rule, instead of just striking down the entire rule. The Fifth Circuit then set the appeal and oral arguments to be expedited, and then they also did something very important. They set a 10-day administrative stay on their decision. What they are doing is giving the ATF and the government the opportunity to seek further relief. Uncertainty looms at the ATF's request. The reason for this is that the ATF initially asked the Fifth Circuit to grant that type of administrative stay when they filed their stay with the Fifth Circuit, so that if they lost at this level of the Fifth Circuit on this day, they could go to the Supreme Court and request Supreme Court review. Now, in response to the Fifth Circuit's order and that 10-day administrative stay, where does this currently leave us with the ATS rule on frames and receivers? Well, the Fifth Circuit has denied the ATF's request to stay the decision. In the request, the ATF seeks clarification from the court on whether the Fifth Circuit's 10-day administrative stay means that the entire frames and receivers rule can still be enforced, or whether only portions of it can currently be enforced. The Fifth Circuit also gave the government a 10-day administrative stay to seek Supreme Court review or other types of relief. But regardless, right now, the ATS rule on frames and receivers is on life support. They have a hard decision to make on whether they are going to go up to the Supreme Court, seek emergency relief from the Supreme Court, and request the Supreme Court to grant an emergency stay pending the appeal. The ATF strategy here would be to argue to the Supreme Court that they need the court to step in immediately to grant their stay, while this case is making its way through the Fifth Circuit appeals process. Of course, this is risky, very risky for the ATF, because the Supreme Court could outright deny their emergency request. Again, this isn't a traditional kind of remedy. It has to go through the Supreme Court. Shadow docket and potential Supreme Court review. The Supreme Court could also take a review of the case and issue an order, ultimately ruling against the ATF. This scenario would put the ATF in an even worse position. Both situations would be unfavorable for the ATF. Their best hope is that the 10-day clock currently ticking might force the Supreme Court's hand and grant them some form of temporary relief. However, it's essential to keep in mind that Justice Alito handles emergency requests that come from the Fifth Circuit, and this case would fall under his jurisdiction. This is not ideal for the government, as Alito is not the justice the ATF would prefer. Additionally, since the Supreme Court is currently out of session, emergency decisions may solely rely on Alito's judgment instead of being referred to the full court. Of course, he can still choose to refer it to the full court if needed, but it adds complexity to the situation. We will have to wait to see what the government ultimately decides to do and what the ATF chooses as their next course of action. However, based on their original filings when they initially sought a stay from the Fifth Circuit, they indicated that if they lost, they would go to the Supreme Court to seek emergency relief. Thus, it's anticipated that they will indeed seek Supreme Court emergency relief. If the ATF goes ahead with seeking emergency relief from the Supreme Court, it would make the case even more intriguing. The Supreme Court would step in immediately to determine the appropriateness of the ATF's actions and whether a stay is warranted on the frames and receivers rule. It adds an extra layer of dynamism to an already complex situation.
I don't have a gun, but I don't give a damn about anybody else having one.
The most serious readily provable offenses in cases where mandatory minimums are present because it's not warranted.
Giving domestic violence abusers a license to kill and essentially preventing the government from doing anything at all about it.
What changed is that item that was submitted was not produced and was not the item that was marketed.
The government quite properly charged him with several crimes.
The sensitive places doctrine was not at issue in this case and still exists.
But then it released him, apparently believing that a civil restraining order instead of pretrial detention was the best way.
He went on to say he looks forward to a quick resolution in the Texas Senate.
Predictably, Mr. Rahimi soon thought, to hell with your restraining order.
Who are prepared and carry a gun oftentimes have to make split-second decisions.
Aggravated assault with a deadly weapon against a different woman using a gun that he wasn't legally allowed to own, but obtained anyway.
In conclusion, the uncertainty surrounding the ATF's stay request and the ongoing litigation over the ATS rule on frames and receivers makes this case highly dynamic. The possible involvement of the Supreme Court through emergency relief further intensifies the situation, with significant implications for the future of the rule and its enforcement. We'll have to closely monitor the developments in the coming days to see how this legal battle unfolds. That's all for this video, folks. See you next time.